Hello everyone, welcome to Master's Teach. And today we are going to discuss administrative law. It is a paper 3. Okay, it is a comprehensive guide for LLB students. If you are newly watching my video, please do subscribe and share with your friends. Let us have administrative law entire lesson in this one. So let us have introduction to administrative law. So what is the meaning of administrative law? Here, the meaning administrative law governs the organization, powers, functions, and duties of administrative authorities. So, what is the nature? It regulates the relationship between citizens and the state, ensuring accountability and fairness. Then, the scope it covers the delegate legislation, administrative tribunals, judicial control, and principles of natural justice. What is the importance? So, it is essential for modern governance, protecting citizens' rights whilst enabling efficient administration. This is about the introduction to administrative law. Then, definition and evaluation. So, here the definition given by the various jurists. Okay, so Ivar Jennings. So, law is relating to administration. As per K.C. Davis, so law concerning powers and procedures of administrative agencies. Wade, so law relating to control of governmental power. So, if you see historical evaluation, so administrative law emerged with the growth of the welfare state concept. Okay, it evolved from minimal state interference to active state participation in socio-economic affairs. Okay, then reasons for growth of administrative law. So expansions of state activities. So modern states undertake the diverse functions beyond traditional law and order maintenance. So social and economic welfare. So welfare state concept requires extensive administrative machinery for implementing social programs. Then administrative efficiency, need for quick decision making and specialized knowledge in complex modern governance. So these are the reason for growth of administrative law, expansions of the state activities, social and economic welfare, administrative efficiency. Then administrative law and constitutional law. Let us see. So let us see the relationship. Constitutional law provides the framework. Administrative law operates within that framework to regulate government functions. Then difference. So constitutional law deals with state structure, whereas administrative law focuses on administrative authorities, functions, and control. Then here constitutional basis, Article 12, Article 13, Article 14, 21, 32, 136, 226, 300A, and 311 form the constitutional foundation for administrative actions in India. Then, basic concept of administrative law. See, administrative authority, administrative discretion, administrative justice. These are the basic administrative laws. So, let us discuss administrative authority. Bodies are official empowered to perform administrative functions, including ministers, departments, and statutory bodies. Then administrative discretion. So power given to the administrative authorities to act according to their judgment within legal boundaries and for public interest. Then administrative justice. So justice delivered through administrative tribunals and quasi judicial bodies, ensuring fairness in administrative decisions. These are the basic concept of administrative law. Then law, rule of law. What is the meaning and importance? Then application in administration. So meaning and importance of rule of law. The rule of law ensure that government power is exercised according to the established law, not arbitrary discretion. It guarantees equality before the law and supremacy of law. Then application in administration. So administrative authorities must act within the legal limits, follow the prescribed procedures, and remain accountable to courts for their actions. Then here, this is rule of law and modern trends. So this is principle, supreme of law, equality before law, predominance of uh, legal spirit. What is the criticism? So this is view was narrow and did not account for welfare state, function or administrative discretion. Then modern trends. So rule of law now accommodates administrative discretion while ensuring judicial review and accountability. These are the uh, disease rules of law and modern trends. So separation of power. So as per theory, decision of governmental powers among the legislature, executive, and judiciary to prevent concentration and abuse of power. So the separation is there. Then position in India about the administration law, not absolute separation, system of checks and balance. Judiciary can review legislative and executive action. So UK and the US. Okay, UK follows parliamentary supremacy with function of powers. USA maintains a strict separation with the presidential system. This is the separation of powers. Okay. Then classification of administrative functions. There are three functions are there: legislative functions, quasi judicial functions, and administrative functions. Here, the legislative functions rule making power to delegate to administrative authorities, including framing regulations and bylaws. Then, quasi judicial functions, so adjudicatory powers exercised by administrative bodies following the principles of natural justice. Then, administrative functions, executive actions including policy implementations, licensing, and day-to-day administrative decisions. These are the classifications of administrative functions. Then delegated legislations, meaning and need. So what is the meaning? So legislation made by the administrative authorities under powers and delegated by parliament, legislature. So why it is necessary? Pressure on legislative time, need for technical expertise, flexibility in administration, emergency situation. What is the importance? So enable the quick response to changing circumstances and allow the detailed rule making by expert in specific field. So reasons for growth. So complex of modern administration, welfare and state functions, and need for specialized knowledge drive delegated legislation. This is about the delegated legislation, meaning and need. Then classification of delegated legislation. So these are the four classifications are there: subordinate legislation, coordinational legislation, executive legislation, sub-delegation. So here, subordinate delegation. So rules, regulation, bylaws made under statutory authority. Then conditional legislation. So laws that come into force upon fulfillment of specified conditions. Then executive legislations, orders and notification issued by the executive authorities. Then sub legislation, so further delegation of legislative powers by the delegated to another authority. This is about the classification of delegated legislation. Then control of delegated legislation. So judicial control is there, legislative control is there, safeguards is there. Then judicial control. So courts review the delegated legislation on the grounds ultra vires, okay, violation of fundamental rights, and non-compliance with the Parent Act. Then legislative control. So Parliament exercise control through laying procedures, scrutiny committee, and power to annual delegation legislation. Then safeguards. So uh, publication requirements, consultation with the affected parties, and parliamentary oversight prevent misuse delegated powers. This is the control of delegated legislation. Then judicial control of administrative action. So here we'll discuss meaning and importance, scope of judicial review. So meaning and importance. Judicial review ensure that administrative authorities act within the legal limits and don't abuse their power. It protects citizens' rights against arbitrary state action. Then, scope of judicial review, review of administrative decision, protection of fundamental rights, enforcement of natural justice, control of delegated legislation, issuance of writs and orders. This is the judicial control of administrative actions. Then, grounds of judicial control: illegality, irrationality, procedural impropriety. So, grounds of judicial control: illegality. So, administrative action beyond the legal authority or violence of statutory provisions includes jurisdictional errors and ultra virus acts. Then irrationality, decisions so unreasonable that no reasonable authority would have made them based on a witness bureau principle of unreasonableness. Then procedural impropriety. Then failure to follow the prescribed procedures or violate the principles of natural justice in decision making process. This is the grounds of judicial control. Then principles of natural justice. There are three principles are there: nemo judice in causa sua, then adi alterum partem, exceptions. So namo judice in causa sua. So rule of rule against bias. No one should be judged on their own cause. So ensure impartiality in decision making. Then adi alterum partem. That means right to fair hearing. Here, other side include notice, opportunities to be heard, reas- reasoned decisions. Then exceptions here: emergency situation, legislative functions, and confidential matter. Uh, may justice depart from natural justice. These are the principles of natural justice. Then administrative discretion and doctrines. So here the administrative discretion is that power to choose between alternatives. So courts control the judicial review to prevent arbitrariness. Then uh, witness bureau principle, doctrine of proportionality. Administrative action must be proportionate to the objective sought to be achieved. Then legitimate expectation. So right to fair treatment based on established practices or promises made by administrative authorities. Then remedies against the state. So here we'll discuss meaning and importance, judicial remedies, types of remedies. So here meaning and importance of remedies. So legal remedies available to the citizens against unlawful administrative actions ensure that accountability and protection of rights. So types of remedies: constitutional remedies, that is called writs. Then statutory remedies, that is appeals revisions. Then common law remedies, damages, injunctions. Then judicial remedies. So courts provide remedies through judicial review, ensure that administrative authorities act lawfully and fairly. So, Article 32 and 226 empower the Supreme Court and High Court respectively. So, these are the remedies against the state. Then, writs, Lokpal, and RTI. This is the important one. Constitutional writs. So, five types: habeas corpus, that is a personal liberty; mandamus, that is a duty and performance; then prohibition, so that is excessive jurisdiction; centaury, that is quashing orders; quo warranto, that is office holding; then lokpalan lokyat, so it is related to the anti-corruption ombudsman at central and state level investigating allegations of corruption against public functionaries. Then right to information, so right to RTI Acts 2025 empowers the citizens to access government information, promoting transparency and accountability in administration. Okay, then liabilities of the state and administrative bodies. So, liability in torts, liabilities in contracts, promissory estoppel, administrative bodies. So, liabilities of the state administrative bodies here, liabilities in tort. So, state liable for tortious acts of its servants under the Acts, Article 300, sovereign immunity limited to after custodial case. Then liability in contract. So state can sue the contractual matters. Okay, Article 299 prescribes the procedure for government contracts. Then promissory estoppel. So state bond by promises made cannot be go back on legitimate expectations created through representation. Then administrative bodies. So tribunal provide the speedy justice, commission uh, of inquiry, investigate matters of public importance, public corporation, manage state enterprises. So here uh, master these concepts and for judicial services and academic excellence in administrative law. So thank you for watching this particular administrative law. Do watch and again you're going to score good marks and you're going to clear your examination. So I'm going to post the same in the description. You can download this particular study material. Thank you for watching. All the best for your coming examination.